He was called to the bar in 1985 and was appointed first Treasury Counsel in 1997. And you did that role until 2008. Yeah. So he will have had a lot of experience of our product. So it will be really, really interesting to hear what he has to say. Over to you.
Well, good afternoon, everyone. Thank you for coming along to listen to me. It's a privilege to be asked to address you. I do so with a certain amount of trepidation since in many ways you all know more about statutes and statutory interpretation than I do, but at least I've been doing it, if you like, on the other side of the curtain for quite a long time, both as counsel and as a judge. So I sort of picked the rather grand title of statutory interpretation in theory and practice. You'll just have to bear with me to see where that takes us. As first Treasury Counsel, 1997 to 2008, I would say that I experienced a period of significant development in the law of statutory interpretation. It certainly felt when I was doing the job that it was an area of the law that was on the move. And at times it felt as Treasury Counsel that the ground was shifting beneath your feet and you were going into court to argue cases. And the cases didn't necessarily seem to have the same complexion when you were there in front of the judge as you had thought that preparing the case they were going to have. And I would say that this period of development has continued since I became a judge. And indeed, I would say that I have in a limited way participated in it. So I wanted to reflect a little on both the theory and the practice of statutory interpretation over this period. That's really from sort of 1990s up till now. So as a basic point, I would emphasize that statutory interpretation is a form of applied constitutional law. The approach the courts adopt to the interpretation of statutes reflects presuppositions about the relationship between the courts and Parliament and the courts and the executive. Although at a basic level, the philosophy of language has some implications, I think, for the approach which has to be adopted to the interpretive exercise. And I would say that it makes a contextual and purposive approach inevitable at some level, as that is necessary to make sense of and give meaning to language. It does not commit us to anything very much more by way of specific details. Many methodological approaches to statutory interpretation are possible within that broad framework, and the one we choose as the determinate methodology to be applied to arrive at particular meanings of statutory texts reflects constitutional presuppositions and commitments. The most obvious of these is a commitment to parliamentary sovereignty. Parliament is the body which has authority to make law in the form of statutes and exercises agency in doing so. One can date the decisive move to this model back to Tudor times. Henry VIII and Thomas Cromwell used Parliament and legislation to give legitimacy to the Henrician break from Rome. As Chris Thornhill writes, during the English Reformation, the principle of rule by the king in Parliament became a key legitimating device of royal government. This meant that Parliament's own authority was enhanced, with the consequence that the courts began to treat the will of Parliament as expressed in the words it used in statutes as having special force. As Alan Cromarty explains in his book, The Constitutionalist Revolution, one sign that people were impressed by parliamentary power was that they placed increasing stress on Parliament's historical intentions. This move has been reinforced in various ways since then, including in particular through the Glorious Revolution of 1688 and the political settlement it brought in, and through the extension of the franchise and the increased emphasis given to democratic ideology from the 19th century onwards. This means that the courts conceive of themselves as faithful agents of Parliament when giving effect to statutes. But this model conceals a lot as well. Interpretation involves much more than reading words on a page. They have to be placed in context, which includes having regard to the purpose for which they are being used. And that gives rise to questions about how one derives that purpose. The purpose of legislation is not usually branded on its forehead, so judges inevitably have a role in determining what it is, and that determination can affect the meaning to be given to the words used by Parliament. In addition, no speech act, including a speech act involving reading the speech down, takes place in a vacuum. Understanding speech involves a lot of presuppositions drawn from the context in which it is used. When the Speech Act is in the form of a formal statement of legal propositions in a statute, the presuppositions include a range of constitutional and legal predicates, which Parliament is taken to have assumed to be in place without needing to state them. I wrote in an article in 2017, statutes are legal instructions transmitted into an existing, highly developed framework of legal values and expectations. The existing law, modes of reasoning, and established localized value systems provide the interpretive context in which a statute is read. Upon receipt of a statutory text, lawyers and the judiciary seek to knit it into the fabric of the law. The statute may represent a radical departure from what has gone before, in which case the existing law still provides the context for assessing how radical Parliament intended the change to be. On the other hand, the values inherent in the existing law, as recognised by judges and lawyers, may be assessed to be so strong as to exert a gravitational force on the text, pulling its meaning in their direction. So some of these presuppositions derive from the common law, or at least, perhaps more accurate to say, from values endorsed and given expression by common law judges, that is, judges drawing their inspiration from the common law, and the way in which judges conceive of Parliament as legislating ordinarily in a manner which reflects common law values. This is the case with the principle of legality. According to that principle of interpretation, the courts presume that Parliament legislates intending to respect a series of rights and principles of constitutional significance, unless it makes it very clear that it intends to override them. Accordingly, writing extrajudicially, I've called the constitutional or fundamental rights and principles derived from the common law's understanding of the Constitution a form of presumptive constitutional order. Aileen Kavanagh, in her recent book, The Collaborative Constitution, which I wholeheartedly recommend, describes the principle of legality as a new label for a centuries-old canon of construction, enjoining courts to interpret legislation in light of constitutional norms, described by other scholars as a common law Bill of Rights or common law constitutional rights. As she puts it, in contemporary times, scholars and judges have rediscovered the potency of the principle of legality as a way of upholding these rights. As Treasury Counsel, I was confronted with this rediscovery and often made submissions aimed at keeping it within proper bounds. This was part of this sort of shifting sands that was my experience as Treasury Counsel at the time, as I grappled with what in effect was a revalorization, re-injection of energy into this principle. And as a judge, I've joined with others in thinking that this is an important endeavour, that is, keeping the principle of legality within proper bounds, so that Parliament's intention is not distorted or undermined, and the legitimacy of the interpretive role of the courts is upheld and not subverted. Some of these presuppositions, by reference to which legislation is read, derive not just from the common law, but from a combination of statute and common law, where particular statutes are taken by the common law to have become embedded as a particularly important and enduring part of the constitutional landscape. This is the area of recognition of statutes as having constitutional significance, on a model first clearly articulated by Mr. Justice Laws, as he then was, in relation to the European Communities Act of 1972, in what was known at the time as the Metric Martyrs case. The effect of this is that the usual rule about implied repeal of an earlier statute by a later one is switched off. Parliament is assumed to have intended that there should be no casual repeal of a constitutional statute, can be only repealed by use of very clear language. And some of the relevant presuppositions by reference to which legislation is read are stipulated by Parliament itself by statute. Such statutes necessarily have constitutional significance because they govern the approach the courts must adopt to interpreting the laws laid down in Parliament. In principle, I would include a statute like the Interpretation Act 1978 in this category. But the two major examples are Section 2 of the European Communities Act 1972 and Section 3 of the Human Rights Act of 1998. Both had a major impact on statutory interpretation in my time in practice and as a judge. The first did so indirectly by stipulating that EU law should have domestic legal effect, and hence leading to incorporation of the strong mal-leasing interpretive obligation, requiring a construction to be given to a domestic statute, which gives it an effect which conforms with an EU directive or other instrument, so long as it is possible to do so in the formulation adopted by the European Court of Justice. The second did so directly by stipulating that primary legislation has to be read and given effect in a way which is compatible with convention rights under the ECHR, again, when it is possible to do so, this time the word possible being used by Parliament. Where one draws the boundary of what is possible in both cases itself has constitutional significance. It gives effect to parliamentary sovereignty on both sides of the boundary. On one side, it involves an application of parliamentary sovereignty, in that Parliament is given an interpretive instruction in relation to its own legislation, which has to be complied with. Beyond that boundary, the interpretive instruction no longer applies, and respect for parliamentary sovereignty implies that one is back to giving effect to the ordinary meaning of the words Parliament has used. Each of these features of statutory interpretation had important effects in my time as Treasury Counsel and as a judge. So I will discuss the principle of legality, constitutional statutes, and the European Communities Act and the Human Rights Act in turn. And I will then briefly discuss issues around purposive interpretation. So first of all, the principle of legality. The principle of legality has developed, or as Aileen Kavanagh puts it, its potency has been rediscovered since the 1990s. In that period, it has also expanded, I think, to supply a theoretical framework which tends to incorporate other pre-existing features of the methodology of statutory interpretation, such as the implied requirement that administrative powers which affect the interest of an individual should be exercised fairly, and the presumption against giving effect to ouster clauses as applied in the Annus Minnick and Privacy International cases. As first Treasury Counsel, I had to contend with this revival and revalorization of the principle of legality. On traditional conceptions, English public law has been more concerned with wrongs than rights, being primarily focused on whether public authorities have breached the obligations imposed on them by legislation. The intensive use of rights concept in public law is a comparatively recent phenomenon. It's associated particularly with the impetus given to the principle of legality in the ex parte Pearson case in the 1990s and cases which followed it. Although public law remains concerned primarily with wrongs committed by public authorities failing to follow their statutory obligations, the content of those obligations is now often informed directly by reference to fundamental rights. The reasoning in Pearson was based on a long-established approach to statutory interpretation that there is a presumption that Parliament does not intend to abrogate rights established under the common law. That is an approach which draws on the idea of rights as positive, institutionally recognised entitlements with specific and determinate content defined by the ordinary law, for instance, rights to contract and so on. But Pearson used the approach with reference to a rather different type of right, a fundamental right of a comparatively abstract kind, one rather more like a principle without clearly defined parameters. Now, this allows for a wider mobilization of judicial power in interpreting statutes, authorizing the reading of words and reading in of words and reading down wide language to make the statute conform to the fundamental right identified by the court. Under the principle of legality, a fundamental right is treated as respected by a statutory provision unless abrogated by express language or clear necessary implication. The idea that the right is fundamental or constitutional appears to authorize a greater role for the court in adapting what Parliament has said when giving it formal meaning to determine a dispute. Prime examples of cases which adopted the Pearson type of approach are Witham and Sims. The classic and much cited formulation is that by Lord Hotham in Sims, which I won't read out because I'm sure you're familiar with it. In Witham, Mr. Justice Laws, and it was him again, well, note he was a very active judge in this period in the 1990s in this area. Mr. Justice Laws identified in the common law a fundamental right of access to the courts and employed that concept to read down a wide statutory rulemaking power which had purportedly been exercised to impose legal fees to use the courts on persons without means. He identified the right by reasoning primarily based on English authorities, but also by reference to Strasbourg authorities. The use of fundamental rights in this way ran in parallel with other developments, using appeals to convention rights in the ECHR in a form of what Lord Roger, in a case called Watkins, called incorporation avant les lettres of the Human Rights Act. Although the theory of the principle of legality is that it respects Parliament's own intentions, there is a tendency for it to operate in tension with both parliamentary supremacy and the rule of law, understood as ruled by predictable and determinate rules laid down in advance. To impose on top of a statutory text an additional interpretive framework by reference to fundamental rights, which are themselves defined at a high level of abstraction and are indeterminate, is to create a risk of distorting positive legal norms into vague, uncertain, and poorly articulated standards. It also involves a practical transfer of lawmaking power from legislature to the courts as the decision makers on the ground, operating this interpretive regime when applying the standards in the particular cases that come before them. If Parliament does not have fair warning of what the words it uses will be taken to mean, its ability to function as an institution which amends the law in accordance with what the elected representative intend and may have promised the electorate that they will achieve will be undermined. The link between democratic will and law will be disrupted. Also, if a citizen does not have a fair warning of what the words used in legislation mean, their ability to plan their affairs will to that extent be undermined. This is not to say that judicial development of the law to identify fundamental rights is improper, but development comes at a price, and over-ambitious development may come at a price in terms of sacrifice of these other key values in our political and legal system, which might be excessive. To contain these disruptive effects, the courts have sought to explain that the principle of legality has a narrow application and is not applicable as an approach to statutory construction in the absence of a relevant established fundamental right or legal principle. For example, in the case of ex parte Stafford concerning the treatment of prisoners, Lord Steyne held that the principle of legality had no application and the relevant wide discretionary power conferred on the Secretary of State could not be read down because there was no relevant and applicable principle which could be said to have been the assumption upon which Parliament entrusted the discretion to him. In a number of other decisions, the courts have likewise been at pains to rebut arguments that relevant common law fundamental rights exist, which can then justify judges in reading down statutes. For example, in the Moohan case, the Supreme Court rejected the suggestion that there was a common law right to vote in elections, which somehow existed prior to, and hence could modify the interpretation of statutes which regulate elections, in that case to the Scottish Parliament. In the Lightfoot case, Mr. Justice Laws warned that, quotes, if the courts were to hold that more marginal claims of right should enjoy the protection of a rigorous rule of statutory construction, not applied in context save that of the protection of fundamental rights and freedoms, they would impermissibly confine the powers of the elected legislature, end quote. This holding reflected a submission which I had made to him as Treasury Counsel in that case. This statement by Mr. Justice Laws has now been endorsed by the Supreme Court in the case of O and the Secretary of State for the Home Department. By treating the principle of legality with caution and keeping it within narrow bounds, the courts have made a choice to protect the general constitutional principle of democratic choice, subject only to limited presumptive constitutional constraints. respect for democratic legitimacy imposes an obligation on the courts to try to be clear-eyed about what background understandings really are so commonly and powerfully held as to inform statutory interpretation in this way by application of the principle of legality. Otherwise, they may put their own legitimacy as impartial, non-political decision makers in jeopardy in the eyes of the public. There is a distinct tendency in the recent jurisprudence of the Supreme Court to seek to fashion legal reasoning around domestic fundamental rights in preference to over-hasty and over-elaborate resort to convention rights under the Human Rights Act. It's not unreasonable, I think, to say that one reason for this is the prevailing political environment in which, after years of hostile criticism of European human rights decisions in certain sections of the press and media, the future of the Human Rights Act had been placed in serious doubt by the position adopted by the Conservative Party. If the Human Rights Act is repealed, the role of domestic fundamental rights may become more important. The tendency to emphasize domestic fundamental rights makes more urgent the task of spelling out acceptable criteria to identify them and their limits, which do not open the judiciary to the charge of making them up on a whim in an illegitimate exercise of practical legislative power. The judiciary need to be able to offer justification for their intervention in the typical kind of case where precisely the legitimacy of that is an issue, namely, where the alleged right is being relied upon to override what might appear to be a clear expression of legislative intention in a statute, or to strike down executive action, where the executive has taken steps to pursue some public interest which it maintains is important, and the existence or ambit of the alleged right is in question. Apart from any political, rhetorical reason, there is a theoretical justification for starting the analysis with domestic law fundamental rights rather than the convention rights set out in the HRA. As I sought to explain in my judgment in a case called Queen on the Application of Z and Hackney London Borough Council, the correct theoretical approach to application of Section 3 of the Human Rights Act is first to construe a statute according to ordinary domestic principles of construction, then to test it against what is required by the ECHR. And if there is no incompatibility at that stage, you stop there. It's only if there is incompatibility that one goes further and asks if some conforming interpretation is possible. So on this ordering, one ought to be applying the principle of legality and domestic constitutional rights before one directly applies the convention rights. However, since the convention rights are expressed in positive terms in statute, there is a strong temptation as counsel and judge to cut to the chase and debate matters in terms of the convention rights, rather than being sucked into the trickier area of identifying and seeking to define the ambit of domestic constitutional rights. One also gets into what I think of as the Johnson and Unisys problem, that it may be difficult for the common law to develop if Parliament has made express provision to deal with the very area in dispute. Also, as noted in relation to the reasoning in Witham, there is scope for reference to convention rights when trying to define the ambit of common law constitutional rights. So I think that the precise relationship between those domestic rights and the convention rights remains somewhat hazy. The principle of legality can be seen as a method at the doctrinal level for domestic law to reconcile two distinct philosophical traditions, the liberal and the democratic, which underpin the liberal democracy regime which has become established in the United Kingdom. But this observation does not carry one further forward in the task of establishing criteria to identify fundamental rights in cases where there is doubt about their ambit. There is no natural a priori basis for reconciliation of the traditions. They fall to be reconciled by way of practical accommodation specific to the political environment of each individual polity. So I think that there is a lot to be said for Aileen Kavanagh's view that the courts and Parliament operate in our polity to some extent as collaborative partners to flesh out the determinate reality of where this balance should be struck in our political legal environment. I turn to constitutional statutes. In his influential judgment in Thoburn, and that is the Metric Martyrs case, Mr. Justice Laws treated certain statutes as having constitutional status and therefore as requiring respect in the interpretation of later legislation in much the same way as by reference to fundamental rights under the principle of legality. In essence, the statute was fulfilling the same function as the constitutional right, common law right, would do when applying the principle of legality. The particular issue in the Thoburn case was whether an aspect of EU law, as incorporated pursuant to the European Communities Act, had been impliedly repealed by later legislation which did not refer to it. On a classical approach to parliamentary sovereignty, the doctrine of implied repeal would have applied, but by treating the European Communities Act as a statute with constitutional status, Mr. Justice Laws avoided that result. The difficulty in this area is that we do not have clear criteria to identify what counts as a constitutional statute. Parliament does not label statutes as being constitutional or not constitutional when it passes them. The difficulty reflects a point made long ago by Frederick Maitland about our constitutional law. We do not have a written constitution as a reference point, and so what counts as constitutional law is really a matter for us of labeling convenience. The reality is that the courts have a super-added interpretive role here as well, in terms of whether and when to recognise a statute as having constitutional significance so as to protect it from casual modification in this way. The general criterion seems to be to ask whether it plays a major role in structuring the state or the exercise of legislative functions. This again may get as close as Maitland did to actually defining the scope of constitutional law. The criterion, obviously, is rather imprecise. It's possible to employ the concept of a constitutional statute to delimit the effect of another constitutional statute. That was the context for its use in the HS2 case in the Supreme Court. Article 9 of the Bill of Rights was treated as a constitutional statute of such embedded and profound significance in our constitutional order as to limit the effect of the European Communities Act, which did not expressly overrule it. So I pass to Section 2 of the European Communities Act itself. In the decade or so before my time as Treasury Counsel, the biggest topic in constitutional law was probably the way in which the domestic legal order had to accommodate the legal order of the European communities, which became the European Union. The effect of Section 2 of the European Communities Act was held to be that developments in the law of the EU, as established in the jurisprudence of the European Court of Justice, later the CJEU, had to be accommodated in domestic law. The three big developments were the direct effect of forms of EU law, which meant that domestic legislation had to be disapplied, as was recognised domestically, not without difficulty in the Factortame litigation. The grant of damages for breach of EU law pursuant to the Frankovich principle, and the application of the doctrine of sympathetic interpretation of domestic legislation pursuant to the Marr-Leasing principle. Under the third of these, the Marr-Leasing principle, the courts had to develop techniques of reading in and reading down. The great example of reading in is Lipster and Forth Dry Dock and Engineering in 1990, in which a significant amount of text was in effect added to legislation in order to make it compatible with the requirement of an underlying EU directive. Since the Marr-Leasing principle was limited to whether reading in was possible as a form of interpretive exercise, the courts also began to explore this question. They were thus brought closer to examination of really profound questions of the exercise of parliamentary sovereignty in the face of EU norms. So Section 3 of the Human Rights Act. I appeared as counsel for the Department for Constitutional Affairs, as it then was called, in the leading case of Guyden and Godden Mendoza. It was, if I can put it this way, a rare case where the government wished me to argue for a relatively wide effect of the Human Rights Act in relation to statutory interpretation under Section 3. The department had policy responsibility for the Human Rights Act and wished to ensure that the courts gave Section 3 the wide effect which had been the policy intent of the government in introducing it. I made submissions emphasising the linguistic and structural analogies with the pre-existing Marr-Leasing interpretive obligation. Linguistic, because both the formulation of the EU principle of sympathetic interpretation and Section 3 spoke of an obligation to adopt a conforming interpretation where that was possible. Structural, because in substance, both interpretive obligations are framed by reference to a form of external or higher law, EU law, and convention rights, respectively. I also argued that the interpretive obligation was framed more strongly than that in the conventional canon of construction to avoid incompatibility with international law, which is framed by reference to a test of ambiguity in the domestic statute, a contrast which was drawn in the white paper Bringing Rights Home. The House of Lords accepted the substance of these submissions, which led to the recognition of the considerable force of the interpretive power and obligation contained in Section 3. Again, identifying the boundary of what was possible was and remains problematic. Lord Nichols and Lord Roger tried to capture the relevant idea by talking about whether a conforming interpretation would cut across a cardinal feature of the legislation, or whether it would run with the grain of the legislation. It's by asking these questions that, in the context of application of Section 3, the courts have to strike in a determinate way the same balance between parliamentary sovereignty and individual rights as they do in relation to the principle of legality. Richard Eakins and I wrote an article in the LQR in which we tried to explore this issue. The relevant interpretive exercise is to ask whether, by the language it has used, Parliament has made it clear that, even though it has not expressly referred to the Convention rights in order to say they are disapplied, it must be taken to have intended to do that in a sort of counterfactual world in which it is taken to have been on notice of those rights. Lord Hoffman's speech in Revenue Commissioners and Wilkinson points towards this approach, as do the speeches in Guyton and Mendoza. Section 3 gave rise to a series of puzzles which have had to be addressed, and so I highlight three more. First, Section 3 applies to legislation passed before the Human Rights Act, as well as that passed after it. Its application in the latter class of case is easier in that one does not really need to address a counterfactual. In relation to that class, Parliament has, by the Human Rights Act, pre-declared the interpretive approach to be applied to the legislation, which it then proceeds to promulgate. It's clearly on notice of the Convention rights, and one can be more confident that the language it has employed is formulated in the light of that knowledge, and so can be treated as a surer guide as to Parliament's intentions with respect to overriding those rights or not. But the same exercise has to be carried out in relation to legislation passed before the Human Rights Act came into effect. Now, that does involve a form of counterfactual inquiry. If the enacting Parliament had been aware, contrary to the world in which it was operating, that a court would later ask whether it intended to respect or to override Convention rights by legislating as it did it make its intention sufficiently plain that the purpose it was pursuing when legislating, apparently in compatibility with those rights, was of such importance as to lead to the conclusion that it is not possible to find a reading of the legislation which does anything other than override them? Ultimately, the question may be much the same, but one feels less confidence in answering it. Secondly, the coming into effect of Section 3 gave rise to a spate of cases in which the retrospectivity of its effect was an issue. Clearly, it applied to legislation which predated the Human Rights Act. But did the interpretive effect it produced apply only to cases involving the application of the law to fact situations arising after 2nd October 2000, the date of the coming into effect of the Human Rights Act? The law was uncertain for a period, but eventually settled down on the position that Section 3 only produced interpretive effects going back to the 2nd of October 2000, and not to the application of the law to fact situations before that. Thirdly, another aspect of the effect of Section 3 was how widely it applied in relation to cases which did not themselves involve any incompatibility with Convention rights. I was again involved in arguing these cases. In Hurst and North London Coroner, the House of Lords accepted submissions I had drafted to the effect that the interpretive impact of Section 3 was confined to cases where convention rights were actually in issue. Sitting in the Supreme Court, I had occasion to reiterate this conclusion in the Zed and Hackney case at paragraph 114. Said this: the proper approach to construction is that legislation should be read and given effect in a particular case according to its ordinary meaning, unless the person who is affected by it can show that this would be incompatible with their convention rights under the Human Rights Act or some provision of EU law as applied to their case. Only then do the special interpretive obligations under Section 3 of the Human Rights Act or under the Mar-Leasing principle come into play to authorise the court to search for a conforming interpretation at variance with the ordinary meaning of the legislation. This means that the same legislative provision might be given a different interpretation in different cases, depending on whether convention rights or EU law are applicable in the case or not. Although at first glance this might seem odd, in fact it is not. It simply reflects the fact that in the one case, circumstances are such that an additional interpretive obligation has to be taken into account, but in the other case, no such obligation is in play. And I cite Hurst and another case. If the position were otherwise, convention rights and rights under EU law would be given disproportionate effect in domestic law, and statutory interpretation would become an exercise in the imaginative construction of theoretical cases in which such rights might be in issue, in order to change the interpretation of legislation in cases where they are not. End of quote. So finally, this afternoon, I turn to the question of purposive interpretation. I think that this is an approach to statutory interpretation which is both unavoidable but also problematic in various ways. The problems are associated with working out what exactly it means and how one identifies relevant purposes in order to carry the approach into effect. Now, I should mention, as a plug for a future lecture, that I'm currently working on a lecture to explore these issues further in my Renton lecture for the Statute Law Society on the 6th of June. But to give a thumbnail sketch of some of the issues that arise. First of all, as I mentioned at the outset, I think that some notion of purpose in the promulgation of a statute is inevitable in order to give sensible meaning to legislation in the first place. In the Packard judgment, I tried to put it this way in terms of saying that a sense of the purpose for which legislation has been introduced is important to set the register for which, according to which the language which has been used by Parliament is then employed. But then questions arise: how widely do you take the purpose? If you're going to treat purpose as something which is going to feed down so as to affect the determinate interpretation and meaning of the words used by Parliament, it obviously becomes quite important to identify what the purpose is. How abstractly does one take the purpose to be? What evidence does one use to draw inferences about the purpose? So the case which these days you will find in decisions of the Supreme Court tends to be cited probably more than any other in relation to statutory interpretation is O and Secretary of State for the Home Department. It essentially summarises the position that we've arrived at through a series of cases down till now. Various reports can be taken into account to determine the purpose for which Parliament is legislating. Explanatory notes, there's a whole history of making reference to explanatory notes. And of course, Pepper and Hart has come into the picture. Now, in relation to all these things, there are rule of law requirements which also need to be satisfied, by which I mean that one needs to bear in mind that when interpreting legislation, one's not having regard only to the agency of Parliament on a democratic basis and what Parliament intended should happen, but also having regard to the fact that Parliament is legislating for citizens who need to know where they stand. And so these two dimensions, both what Parliament took itself to be legislating to achieve its purpose, but also that it's legislating for citizens who need to understand where they stand in relation to the law have to be taken into account. In a particular way, I addressed this particular issue in relation to the move from notes on clauses under the old dispensation to published explanatory notes in a case called PCSU, which, at first instance, essentially, I was confronted with arguments where people were saying I should have regard to notes on clauses, which had not been published, in the same way as one would now have regard to explanatory notes, which have been published, in order to interpret primary legislation. And I held that that would be inappropriate because the citizens to whom the primary legislation would be applied did not have access to the notes on clauses. And so they could not themselves refer to them in order to inform themselves about the proper meaning of the legislation. That was a ruling which actually accords with things that Lord Diplock said in a case called Fothergill. Again, emphasising essentially the rule of law requirements that Parliament is taken to comply with. So essentially, where these sorts of considerations take me is to an idea that purposive interpretation is necessary, but that what we have regard to by way of trying to identify the purposes and the materials that we look at should be kept within pretty narrow confines so as not to destabilise the meaning of the legislative text more than absolutely has to be done. And we need to recognise that there is a tension here between giving effect to what Parliament's policy intent may have been in the most faithful way, but also recognising the impact of the rule of law considerations and the effects on the citizen. I'm not going to, with an eye on the time, I'm not going to say more about that now. As I say, I've given my plug for further consideration for this quite difficult topic. But I think it is worth just reflecting on the problems that are associated with identifying purposes and so on. You will find now lots of statements in the Supreme Court from myself and my colleagues saying, well, the modern approach to statutory interpretation is a purposive approach. I don't have any problems with that, and as I say, I've said it myself, but it does conceal certain underlying puzzles and difficulties. And where it brings me out in terms of what approach one should apply is that in many ways, statutory interpretation comes closer to common law models because very often you can identify a series of different purposes of greater or lesser weight which are being pursued when Parliament has legislated in a particular way. Often there's a tension between ends and means, whether a particular end should be pursued in ways which involve procedures which have to be respected, and what is the balance between those, or between different ends. In a case called A1 Properties Limited, where I was a party to the judgment recently, we had a consciousness that there were purposes going in different directions. What does a purposive approach to interpretation mean if you're confronting that? And essentially, what I think the courts are drawn into is a form of common law balancing of different values and purposes, giving them what weight you can, as best you can within the context, and giving them a level of priority in much the same way as common law reasoning proceeds by giving levels of priority to different values inherent in the common law. And so in a strange way, I find that my practice of statutory interpretation feels very close as an intellectual exercise to my practice as a judge interpreting the common law. So on that thought, I'll stop. Thank you very much.
So much. That was